The topic I will be discussing today is whether a person or a couple should make a will. The short answer is yes. Before I discuss specific situations, let me state a few things in the hope of clearing up some misconceptions. First, the law of wills is state-specific. That is, each state has its own set of laws governing who can make a will and the formalities one must comply with in order to make a valid will, one that a court will enforce. Second, generally, a person who wants to make a will needs to be 18 years old and of sound mind, which means that the person has to know that they are making a will, that they know the nature and extent of the assets they own, and that they know the natural objects of their bounty. In other words, you have to know what you are doing and why. A written and signed document is required in almost all but a few special cases, and most states require that two other people also sign the will as witnesses. Some states do not require witnesses, as long as the document is signed by the person making the will, known as the testator, and the material portions of the will are in the testator's handwriting. The main reason to make a will is to make sure that, upon your death, your property goes to those persons you want your property to go to. A will can accomplish that objective and do so in a legally accepted manner. If you do not have a will, then you die intestate, and the law of the state you live in will step in and make the decision for you about how your property will be distributed and to whom. Again, each state has its own rules, and each person's family situation is different. In another presentation, I discussed the general rules of intestacy, so I will leave that issue for now. There are other reasons to make a will, and they are as varied as each family's dynamics. Providing for children, especially minor children, providing for partners, providing for aged parents, minimizing taxes, selecting fiduciaries to handle your affairs, selecting guardians to raise your minor children, and making sure that there is an orderly process to reach your distribution goals are but a few of the many other reasons. Let me give you three typical scenarios. First, a young, unmarried person just starting out in his or her career. Second, a recently divorced parent of two young children. And finally, an older couple with grown children who have started their own families. First, the young unmarried person. Just starting out in your career, you might feel that you do not have enough assets to bother with making a will. That may be true, but even if it is, things could change quickly. You could inherit money from a parent or a grandparent. You could get injured and receive money either in a lawsuit or as a settlement. Regardless, you have your own ideas about how your property, whatever the value, should be distributed upon your death. Everything to your partner, if you have one, some to your parents, some to your brothers or sisters, or a favorite niece or nephew. How about to a favorite charity? And if you have pets, who will take over their care? Without a will, your preferred beneficiaries may or may not receive your property when you die. And with a will, you choose an executor or executrix, someone you trust, to make sure your testamentary plan is carried out. Let's consider another example. The recently divorced parent of two young children. In this situation, your primary goal will probably be ensuring that your children are taken care of if you pass away. For you, there are two major concerns. First, who will be the guardian of your children? That is, who would you want to raise your children if you pass away, and your ex-spouse has either passed away, is unfit to raise the children, or simply does not desire to do so? An elderly parent? A sister in a faraway state? A successful sibling who has married and has children of his own or her own? In a will, you choose who will be the guardian of your children. While your choice is not absolutely binding on the probate court, it will be given great deference. And it would be a good idea to select an alternate guardian in case your first choice of guardian is unable to take on the role of guardian. Second, how will your property be distributed? This situation also requires careful thought and planning, and may involve providing money to the guardian to help pay for the cost of raising your children, and even setting up trusts for things like their college education. And finally, the older couple with grown children who have children of their own. Will there be enough money to ensure that the surviving spouse can live comfortably? What happens to the estate when the second spouse dies? To whom should the property go? The wealthy and successful daughter? The son struggling to raise a family with his spouse? siblings in need of financial support, or specific grandchildren? What about grandchildren yet to be born? And what about planning for Medicaid eligibility and long-term care? Finally, what about estate taxes for those fortunate to have had financial success? The list of issues to be addressed goes on and on. Whatever your current situation, it is probably a very good idea to consider making a will. At a minimum, making a will gives you some peace of mind, knowing that if anything should happen to you, your wishes upon your death will be honored.